Tonight we're going to talk about agreements of purchase and sale with Don Donahue and Wayne Rosenman. And before we get into agreements of purchase and sale, perhaps you'd like to just check and make sure you've got the right things in your workbook and your lecture book. The first part of your book is lectures, and you start off with the introduction. After the introduction, you have, I think it's Rule 2, and then the reference materials. After that, I believe, comes the first lecture by Brian Bucknall on what's new in cases and statutes. After that comes the second lecture, Ian White, on billing and timekeeping. And attached to that is the material that we got from Alan Marshall, also on timekeeping and office organization. That's in the first part of your book so far. There's also the lecture by Brenda Duncan on what your client should know and do, and the lecture by the surveyor Lorraine Setterington. That's in the first part, your lecture part. If you're missing something, I think there's still copies at the desk. But maybe if it was material handed out other than this week, you might have to check upstairs at the department. You have your fact situation, and you have the added facts. Remember, I told you, because we were drafting, after we had done the facts, we realized we had to invent a few more facts. Since the whole thing was an invention anyway, we just went ahead and invented. So you should have your fact situations, rural and urban, with the agreement of purchase and sale right beside, because that's what you're going to be working on this evening. And your added facts, you'll really need more for when you come to doing the drafting. We've looked at your workbook about pages 1 to 30. That was the introductory material and the steps in a real estate transaction and your first letter to a vendor and purchaser and so on. This evening you've been given another batch, and you should have your workbook material up to page 102, I believe it is. We'll be dealing with those materials next week, largely. Next week, you'll be given your evaluation sheet, which is pink, and you'll be asked to hand it in at the end, but maybe you'd make notes as you go along. Evening 1 and your comments, evening 2 and your comments, and so on for the 6 evenings. So that what's good we can keep, and what's bad we can throw out, and what needs changing we'll change. If your comments are from the heart, so much the better. Your questions, if you could write your questions and give them in to us at the break or the end, or take them up to Continuing Education Office, we'll try and answer them as we come along. We've had a few, and we'll incorporate the answers. If you're still not satisfied, keep trying till you get the best we can do anyway. One of the things that came out of the lecture that we had from the surveyor last week, while it wasn't emphasized in these words, I guess it's fairly clear to us now that we don't ask surveyors to draft wills, and we don't take out appendices, and I guess perhaps we better not draft any descriptions. That's, I know it's temptation, but now that we know what's involved, I guess perhaps we better stay away. That reminds me to ask you to look at page 23. That's that first letter to your purchaser client. And you'll see in one of the last paragraphs, it mentions that you are drawing to the attention of your client, they might want a sketch of survey. In the light of what I learned last week, let's cross out sketch and put plan. And you may also want to add to that letter 2 things which have been brought to my attention. The letter to the purchaser, you might want to mention to your purchaser client that they may wish to change the locks when they take possession, so they can order their locksmith same time they're ordering their meters read and the phones installed and all the rest of that. And also that the post office makes available for people who change address a little card that you can leave at the post office, plus cards that you can send to your friends. Don't panic if you haven't got your table of contents. As I mentioned earlier, the table of contents is coming, and it will come when we have all the material in. We've got one lovely group of material that's still in the course of being put together, and I think it's worth waiting for. This evening, when we're talking about agreements of purchase and sale, you'll probably fill in on one of those checklists, or maybe two of those checklists, the date that the agreement of purchase and sale was entered into, because then your time starts to run for your requisitions and so on. And when you're filling in checklists, that's the kind of detail that you need for your tickler system. And that will be gone over, I imagine, by both of our lecturers, but we'll have to wait and see. As I told you, our faculty is widely diverse. We have people from small firms and large firms, and people with 10 years of practice and people with more than 10 years of practice, people from in town and people from out of town. And Don Donahue just about combines all those. Don Donahue, who graduated in '58 from Osgoode, has practiced both with small firms and with large firms. And he says, I grew up in the country, so I'm rural, and I practice in the city, so I'm urban. So I guess he's got all those things going for him. He now practices with a very large firm, and in his spare time, he lectures for the Law Society of Upper Canada. He also finds time to be chairman of the Real Property section of the Canadian Bar Association, and I'm anxious to hear what he says about agreements of purchase and sale. Don?
Thank you, Miriam, and thank those of you who were able to come out this evening. You'll find in the workbook some 41 pages of a lecture under my name, and if some of it looks familiar, it's because you've already read that lecture in the 1975 Law Society session on agreements of purchase and sale, or in the paper under my name in the Errors and Omissions program of last year. Miriam gave me permission to copy some of it because I just couldn't come up with a new way of saying the same thing. Anyway, I'm not going to present that lecture this evening, so you can close your book, maybe read it later. I find it terribly disconcerting to look down at an audience that is following along line by line. The last time I did one of these things, I made a mistake at one point, and half a dozen people corrected me. The printed material deals with the topic of agreements of purchase and sale generally, but tonight I propose to make some of the same points as I make in there by reference to these two fact situations which you already have. If I sound a little confused at some point this evening, it's because I just 5 minutes ago received the supplementary facts, so I'll try to fit those in as I go. Miriam has suggested that you may want to fill in the blanks in the form of agreement of purchase and sale that's in the material as we go along, just after the buff-colored divider in your workbook. First of all, let me say a word about that, the printed form that you find in there. You'll find both the Ontario Real Estate Association and the Toronto Real Estate Board printed form. They're almost identical. There's a couple of changes, which I'll mention later on. Both of these organizations have accepted some suggestions from the Canadian Bar Association, Real Estate Section, and that committee, a committee of the Canadian Bar Association, is once again this spring making representations to both boards, requesting them to make certain changes. Now, you must realize that all we can do is ask them to make the changes. They print the form for their convenience and for the convenience of their agents, but they've been fairly helpful to us in the past. If you have any suggestions about changes in that form, problems that are arising in your practice, can I ask you, as a plug for the Canadian Bar Association, contact Donald Milne of Blake Castles, he's the chairman of the committee, or Alicia Forgy of Osler Hoskin, or Miriam. The three of them comprise the committee. There are a couple of serious problems in that printed form, and I'll deal with those as we go through, but we'd like to improve it if we can, bearing in mind that the boards will only do it if it suits them. Don't ask us to change the commission clause, because they won't. Every time we go to a meeting, they say, we'll listen to you, but don't even talk to us about the commission clause. Now, like all printed forms, it's dangerous to use without carefully considering whether each of the sections fits your specific fact situation. In order to do that, you've got to know what's in that form. My preference, and of course my recommendation to you, is not to use a printed form at all in any but the most routine residential properties. And of course I realize that we don't have much option in that anyway, because usually by the time we see them, they're all signed. Well, let's look at fact situation number 1, the rural property. In this hour, in my lecture, I am supposed to be acting for the purchaser. And since we know who our client is, you can just fill that in very simply. Cowardly Developments Limited. Now, there's no indication in the material, the fact situation that we've been given, that Cowardly Developments Limited has any intention of assigning its rights. So we don't have to draft a clause to deal with that. But let me just remind you that unless an agreement of purchase and sale specifically prohibits assignment, a purchaser may always assign his rights under an agreement of purchase and sale. There's authority for this in Section 54 of the Conveyancing Law Property Act. Any absolute assignment made by writing under the hand of the assignor of any debt or other legal shows in action, and take it that this is a legal shows in action, of which express notice in writing has been given to the debtor, trustee, or other person to whom the assignor would have been entitled to receive or claim such debt or shows in action, is effectual in law. And if you ever get into a problem on that, I did just last week. I found a case, Bretton, B-R-E-T-T-O-N, Land Company Limited, and Damore, D-A-M-O-R-E, Construction, 1956, 2OR42. But it's all very well that a purchaser has the right to assign, and the courts will enforce the agreement in favor of the assignee, unless there is a specific clause in the agreement allowing that. The named purchaser will remain on the covenant. For instance, if the agreement is that he's going to give a mortgage back on closing, the first named purchaser will have to go on the covenant. So too will the assignee. But the first named party was the party that the contract was made with, and he must go on the covenant. If you have any argument on that, you might look at the case King and Urban and Country Transport, 1973, 1 Ontario Reports, 449. Now, to solve that problem, if you're into it, on page E3 of my lecture, I've included a clause which makes it clear that upon assignment, the original contracting party is released and the new party is the contracting party. Remember also that Section 54, if you want to assign it, you can do it, but it specifically requires that written notice be given to the vendor. And if written notice is not given to the vendor, the courts will not give specific performance to the assignee. And that was established in the case of DeGilio and Boland, 1958, Ontario Reports, 384. Now, the fact situation, at least the one I was looking at when I wrote this thing, it says that the vendors are the personal representatives of John Fastbuck, deceased. And of course, I've never seen an agreement that says that. Once you become aware that property is an estate asset, I think you must make further inquiries before completing the agreement. You'll have to get a copy of the letters probate or letters of administration to see who is authorized to deal with the property. Do the executors have power of sale? Has the property vested in the beneficiaries because 3 years has passed since the date of death? Is the estate selling for the purpose of distributing the proceeds? Now, of course, it's true that you can later check these matters and send in a letter of requisitions to get the right people signing the deed. But if the right people didn't sign the agreement, you will not be able to sue and get specific performance against them. If they didn't agree to sell, no court is going to force them to sell. There's a case on page E7 in this regards. So for our purposes, we'll just fill in as vendor. And now that I have the supplementary facts, Joseph Smith and Mary Jones, executors of the estate of Fastbuck, deceased, and Irma Fastbuck, the widow. The next blank is for the agent, and I usually leave them to look after themselves. The property. In the printed material, I run on for about 12 pages talking about a description of property. This fact situation illustrates a couple of the problems that arise. It's simply too vague. It says part of Lot 2. The question is what part of Lot 2? And it says 95 acres more or less. I think before preparing an agreement like that, you want to talk to your client and find out just how much more or less he will tolerate. Find out if he's walked the lines and can he identify the property. I'll leave this topic to Wayne, since as solicitor for the vendor, he has access to the description, and it's his responsibility to make sure it is used. In the printed material, I've referred to a case that I found very interesting, Charter, York, and Hurst, in which an agent prepared an agreement. It could just as easily have been a solicitor, and he didn't carefully describe the land. The deal fell through. The purchaser did not want to close. The courts refused to force him to close because they said the parties were not ad idem. The property was incorrectly described. Damages were set at a maximum of $500,000 against the agent because of his negligence in describing the property. So don't casually put down part of the lot. Obviously, if you can, you'd want to say, as shown on the plan of survey attached to Schedule A, if there is such a thing. Or, if it's everything that John Fastbuck owned, you could say, as described in an instrument registered as number so-and-so. It's always risky because he may have sold something since that date, or something may have been expropriated. Purchase price is set. We just fill that in. The deposit is set. I have no comment on a $2,000 deposit. Wayne may. Balance, certified check, subject to adjustment. The agreement sets out an allocation, and I think you're all aware that in any agreement where there are assets and property to be used for producing income, you want an allocation. The Income Tax Department, Department of Revenue, will normally accept an allocation arrived at between the parties at arm's length. For my part, if I were acting for the purchaser, I would question the allocation of $35,000 for the building. Obviously, we would want it higher. Now we come to the big white space in there, in the agreement, where we fill in the conditions. In the printed material, I've dealt with conditions generally from pages 30 to 33. And on pages 32 and 33, I've set out my recommendations for the language which you should use in an agreement for the creation of conditions. There's two forms. I think one comes from Miriam, one comes from me. I think they both work because in both cases it's clear that these conditions are there for the benefit of the purchaser, and that the purchaser, and only the purchaser, may waive. They do not create what the Supreme Court of Canada in Turney and Zilka called a true condition precedent. If you put a condition in an agreement and so word it that it comes within that definition of a true condition precedent, then you're stuck. You cannot waive it. And the courts have said in that cases and cases following it that if the condition has not been complied with, then neither side is able to enforce the contract if the other side wants to walk away from it. So the important thing to get in a condition is the right to waive it. Now the first condition in this one would be financing. I find it odd in the fact situation that it is so specific on the terms of the mortgage, even going so far as to specify collateral security and that the interest rate for the renewal is to be governed by the rate charged by a specific lending institution. After all, the intention of a condition is to allow the purchaser to go out and arrange a loan. In this case, he needs $150,000. He'll arrange it at whatever terms he can. Until he has a commitment, he won't know all these details. If he has a commitment from Farm Credit Corporation setting out all these terms, then he doesn't need a condition. I'm just puzzled as to how we got into this fact situation. However, as to the form of the condition, I've set out my suggestion on page E26. It's different facts and numbers because I didn't have the fact situation at that time, but it sets out, I think, a condition that is usable. A second condition concerns survey. On page E17, I've suggested a condition concerning a surveyor's certificate of acreage. And in this situation, I think we should add in our contract, the purchaser hereby agrees that the balance due on closing shall be increased by an amount equal to the number of acres or fractions thereof shown on the said certificate in excess of 95 multiplied by 1,000. I find that unusual. Normally you agree to buy so much an acre, but here I guess they've decided on a certain price, and if it happens to be more acres, they'll pay a little extra. Third condition concerns the Planning Act, and I refer you to the Ontario Real Estate Association, item 12. Well, both agreements have the same condition. That condition is in all agreements, the agreement is to be effective only if the subdivision control provisions are complied with. Incidentally, I think the way that's set up is it is a true condition precedent, and I guess it should be, because if the subdivision control conditions are not complied with, there's no way you could close. The fact situation uses the words that the agreement is to be conditional upon the vendor obtaining severance. I really don't think that that is what is intended, because it goes on to say that if he can't get severance, in fact the purchaser will close and the vendor will sell upon payment of an additional $5,000. I think you'd want to draft the contract so that it is clear that that will happen. And you'd have to give a certain amount of notice. I would say if you didn't have the severance before, let's say 10 days before closing, the purchaser would be notified, the purchase price would increase by $5,000. There's an interesting little sentence at the bottom of the page. The agent says that the purchaser need not worry about the local conservation authority. I think we all know enough not to rely on what the agent says. After all, he wants to get a contract. I remind you also that in these printed forms, they all carry Section 20. This agreement shall constitute the entire agreement between purchaser and vendor, and there is no representation, warranty, collateral agreement, or condition affecting this agreement other than as expressed herein in writing. Incidentally, if you've got that open, it is an example of the problem with printed forms. I have been on a committee, I've redrafted, I've used it for 20 years, I've written a book about it. The other day somebody asked me, what does the middle of the second line mean? And I'm damned if I know. The words "or supported hereby," they just don't make sense. This agreement shall constitute the entire agreement, and there's no representation supported hereby. But anyway, it's there. We'll try to get that out next time, Miriam. This conservation authority problem is it's a big one. If you look at page 64 of your material, I'm not sure if you have that yet, but if you do, you'll find that there are approximately 40 conservation authorities around this province. Any property that has a river or a valley, cliff, whatever, on it probably is subject to the Conservation Authority, and you know that the conservation authorities do not expropriate, and they normally don't buy property, but they have the power to freeze the use of the property so that while you pay, in this case, $5,000 an acre, you can't use it at all. So this should be a very important condition that you put in, make it conditional if it's important, that no part of this property is subject to Conservation Authority. Well, the next thing that I found interesting in this fact situation is the milk quota. I guess, as Miriam says, that's because I come from the country, and in all the time I've been practicing in the city, I've never dealt with a milk quota. However, we have to be aware of them, and there isn't just milk quotas. There's the turkey marketing board and the hog marketing board and the, I don't know, whatever they grow out there is subject to marketing boards, and most farmers in most tobacco is the same. They are subject to quotas, and those quotas are not automatically transferable. No one under milk, no one in Ontario can sell milk, any kind of milk, unless he has a quota that's issued through the Ontario Milk Marketing Board. They have two kinds. There's the kind of milk we drink, and there's what they call industrial milk. So that it is essential in a situation like this that there be a condition that the purchaser is able, on or before closing, to obtain the consent of the board to this transfer. And I'm told, I called up the board, they're most anxious to help, they'll give you all kinds of material. I'm sure all the other boards act the same way. They also pointed out to me that on any sale of a farm that has a milk quota in Ontario to anyone other than a member of the family, the quota is automatically reduced by 15%. So if you're acting for a purchaser buying a farm, it would be pretty important to tell your client that. On page E40 of the printed material, I've dealt with a 1978 decision of Mr. Justice Steele, Olson and Poirier. That concerned I think it was a Danish immigrant who was enticed to come over to Ontario and buy a dairy farm by a real estate agent who held himself out as an expert on dairy farms. The deal closed, and only after he closed did the immigrant discover that at that time the milk quota was reduced by 25%. That meant he had 100 cattle, but he could only produce from 25. There's nothing you can do with that milk. The court ordered rescission. It gave the purchaser back his money. They found the agent negligent and awarded considerable damages. The same sort of condition is important if you're dealing with a licensed premises, hotel premises, a bar. You have to make it a condition that the purchaser is able to get approval. The risk in doing this, of course, this is Wayne's side of the coin, but the risk in that sort of a condition is really that you're giving a free option because, for instance, getting a liquor license approval, any applicant can always make sure that he doesn't get it if for some other reason he wants out of the deal. I even found out something about the Holsteins. When Miriam first met with us, both Wayne and I said, well, we'll do it, but what are we supposed to do about these cows? Well, I find out that registered Holstein cattle are registered with the Holstein Friesian Association. They all have a number. And Schedule A would have a list of those numbers, and they'd all have names, and they all have 3 names. I think the only condition you'd want to deal with there is that on or before closing, the purchaser, the vendor produce satisfactory evidence that all health regulations have been complied with for each of these cattle, vaccination certificates, inspections, and so on. Well, that's conditions. Let's go on just quickly through the agreement to the various paragraphs. The paragraph numbered 3. All existing fixtures are included except, well, apparently there's nothing being accepted. We have a list of chattels that are being included. Review the list with your client to make sure everything that he wants to run this business is included. Now, probably there'll be a truck, some automotive vehicle in it. whenever you're dealing with an asset purchase with automotive product, remember that in order to transfer the license on the closing date, somebody's got to produce a certificate of fitness, just like when you and I sell our car. And it shouldn't have to be reminded, but I find it does, that if we don't deal with it in the agreement, people forget about it. You come down to closing and they say, sure, here's the permit, but it really isn't transferable yet. Paragraph 4, any agent will tell you don't give them too long to think about it. Paragraph 5, the closing date, our fact situation hasn't specified it, but let's fill in. Oh, did it? I'm sorry, I didn't read that part. 17th of March. In any event, when you're preparing an agreement, do yourself a favor and don't pick a Friday and don't pick the last day of the month. We all know what it's like in the registry offices, the lineups and so on. We've had meetings, incidentally, the Canadian Bar Association, along with members of the Ministry of Consumer and Commercial Affairs, with both the Toronto Real Estate Board and with the Ontario Real Estate Association to try to get the message through to them and from them down to their agents to try to persuade them not to close everything on the last Friday in June. So we should remember it too. Paragraph 6 is the one that right now is causing us the problem and is the reason why we want to have this agreement changed, and that you should be changing this agreement if you get a chance. The fact situation gives us only 10 days to search the title. Now, it may be possible to get out to Brampton and search the title and have your requisitions prepared and have them delivered, not mailed. Remember, the case of Steichhold and Maynard says that they must be delivered within 10 days, not just prepared, not just mailed. That may be possible, but it simply is not possible to do all the other things that are buried in the fine print in that paragraph. You have 10 days to examine title. You have 10 days to satisfy yourself that there are no outstanding work orders affecting the property. You have 10 days to satisfy yourself that its present use may be lawfully continued. And all of you, I think, are aware of the delays that we run into in the municipal offices trying to get answers on work orders. And yet, the cases are clear, and there are, I suppose this is the biggest area for claims against lawyers that we found in our errors and omissions program. Negligence by lawyers in not getting the answers to these, in not checking, or checking too late. The case that's got everybody upset right now, I'm sure you're all aware of it, Jackson and Nicholson, the citations on page E37. Here it was an agreement just like this. It gave so many days to do all these things, and after the date went by, the solicitor for the purchaser, he tried, and he did get an answer that there was a breach of a zoning bylaw. It could just as easily been a work order turned up. The purchaser said, I don't want to buy this property subject to the work order or to the fact that it's not zoned for the use that I'm buying it for. The court said that the breach of the zoning bylaw is not a matter of title and is not a matter of conveyancing, and as you know, those are the two things that you can requisition right up to the day of closing. They said it's neither of those. Therefore, the contract must be enforced in accordance with its terms. The terms were that the purchaser shall be allowed 10 days in which to do this. And if you look over in the fine print on paragraph 9, if within the time allowed for examining the title, any outstanding work order or the present use may not be lawfully continued is discovered, and down to the last line, save as to any valid objection so made by such date, so that you're stuck with it. So 10 days simply won't do. I suggest you take all of that stuff right out of the clause if you have a chance, or if you're drafting your own, don't combine the date for closing, for searching title with the date for satisfying yourself on these other matters. Needless to say, I think it's clear the decision in that Jackson and Nicholson case was that the purchaser had to close, and the court awarded specific performance. despite the fact that he couldn't use the property. Paragraph 9 over the page has buried in it those words. The title is, that's the main condition to any agreement, of course, provided the title is good and free from all encumbrances, except for any registered restrictions or covenants with the land, running with the land, providing same are complied with. That's pretty rough when you haven't searched the title and you don't know what registered restrictions are there. Even though it's allowed by the zoning bylaw, there may well be a registered restrictive covenant preventing the very thing your client wants to do. And if you've had a chance to look at the agreement and you haven't deleted it, your client's going to be pretty unhappy when he comes down to closing and you tell him, well, it's too bad, but that's what the agreement says and you have to close. Now, on the second fact situation, the second agreement, the Toronto form. Before we go on, let me just point out that a couple of very minor changes. They look very much the same, and in fact the number of paragraphs is the same, but if you look on the back of both of them, you'll find that paragraph 13 is entirely different. The Ontario Real Estate Association has not yet deleted the completely unnecessary now clause, purchaser hereby warrants that he's not a non-resident of Canada pursuant to the Land Transfer Tax Act. There's no need for that now. And in substitution for that, the Toronto form has put in vendor shall deliver on completion registrable evidence of compliance with the Family Law Reform Act. You see, they've gone quite differently there. If you look at the bottom of the Ontario form, they have a place for the spouse of the vendor to sign, consenting to the disposition, whereas the Toronto board, I think on our recommendation, Miriam, at the last committee meeting with them, deleted that paragraph entirely, and they just have a covenant by the vendor that he will comply with the Family Law Reform Act. There's arguments both ways on that as to whether you should get the spouse joining in right from day one. There's no requirement at law that she do so. She's going to have to join in the deed anyway, but it might be easier to get specific performance if she had. I found this this house a bit of a puzzle because it's a single-family dwelling, but it has an apartment on the second floor, and it's said to be new, but somebody put firewood in the garage and planted rose bushes and Japanese elm trees, and it has both a TV antenna and a cable TV contract, but that's what it is, so we'll try to prepare an agreement. The parties are very simple this time. There's no agent. The description of the property is very straightforward. Just fill in the blanks. You're going to have to say that property's on the something side of Green Street, since it's an odd number. It's got to be either in the east or the south, at least in Metro. I don't know what it is in the rest of the province. It's essential, though, in preparing that description that you put in reference to the mutual driveway. Because if it isn't there, I think the man could back away from it if he came down to closing and said, no, I agreed to buy a house, not a house subject to an easement. Purchase price is set out, the deposit is set out. The balance of the purchase price, I find, I know it often happens, but I think it's back to front. I think we should have a second mortgage for a specific amount and the cash balance subject to adjustments, instead of, as here, a specific amount of $24,000 with a mortgage for the balance, because after all, you're not going to know the balance for some time. In all jurisdictions except Ottawa, where they insist still on doing things backwards, the purchaser's lawyer is going to draw that second mortgage back, and until he knows what the balance due on closing, he couldn't do it. So I think you reverse that. I find it also, well, I can't imagine drawing an agreement and saying that the purchaser will give back and the vendor will accept a second mortgage for $41,000 to bear interest at no more than 16%. Either it's 16% or it isn't. And in blended payments of principal and interest not to exceed $540.82. Surely the parties must decide that. It can't just be left open. As to conditions, on page just find one here I want to use. In this situation, the purchaser wants to purchase what is characterized as a single-family dwelling, but he wants to assume the tenancy of the second-floor apartment. I've got one of those right now. A client of mine, partner as a matter of fact, wants to buy a well, I think it's legally a duplex, but it's got a third apartment in it, which is not legal. And he says, that's all right, I don't care. Well, that's fine if he wants to do that. But again, I give the same line as I gave in the Errors and Omissions program. For goodness sakes, get it in writing to him, confirming that you told him that the use is illegal, and he said, okay, go ahead. Sure, there was something here. Well, I've lost the page I wanted to read from, so we'll skip that point. Swimming pools, I think, should be referred to in the conditions, too. There's a lot of fly-by-night swimming pool contractors, and there are some very strict rules about where you put a swimming pool. As I found out when I tried to put one in my backyard, the 6-foot easement at the rear of the property is supposed to contain the hydro lines. It doesn't. Hydro lines are way into the middle of the lot, which shouldn't be my problem, but it is, because you can't construct a pool within a certain distance of the lines, whether they're legally there or not. So I think there should be a condition that the pool be constructed in accordance with local building bylaws and that it's fenced in accordance with local bylaws. The requirements vary from municipality to municipality, but most municipalities, certainly in the metropolitan area, have a requirement that a swimming pool be fenced with a certain type of construction and a certain height. And quite often these requirements vary from the building restrictions that were imposed by the subdivider. He says you can't put a fence higher than 3 feet, and the bylaw says it must be 5 feet. I think you go with the bylaw. This fact situation says that the purchaser wants entry to the property, not once, but 3 times. The first one is said to be an inspection before making a binding offer. Well, that inspection should be completed before the offer is signed. I point out to you paragraph 8 in both these forms. The purchaser acknowledges having inspected the property prior to submitting this offer and understands that upon the vendor accepting this offer, there shall be a binding agreement of purchase and sale. Otherwise, what would you say? You'd have a condition, but it would be awfully broad. It would be that you have an agreement, but the purchaser will have so many days to satisfy himself by inspection that that's something. I don't know what he's looking for, so I don't know how you draft that condition, and once you do draft a condition, no matter what it is, I think you've converted your offer into an option. Inspections by professionals are becoming very common, and I'm very glad these people are there. There's companies who make a business of advising prospective purchasers. You can find them in your yellow pages. I've recently received brochures from a couple of them, Home Inspection Consultants of Ontario Limited, Carson Dunlop and Associates Limited. They advertise that within 48 hours of your phone call, they will go in, inspect, and give you a written report on all construction details of that house. If you want to find them, they're in the yellow pages, at least in Metro, under Building Inspection Service. Now, the next one, he wants to come in within 24 hours of closing to measure for drapes and carpets. Well, that's easy to draft and easy to enforce. But I don't know what you're going to do with the request to inspect once again 24 hours before closing. I mean, it's easy to give him the right to inspect, but what's he looking for? And if he finds it, what then? You're going to have to be more specific than that. Is it that the agreement's going to terminate, or is there going to be an abatement of purchase price? You'd have to go over that with your client to see what he's concerned about. Obviously, if you have a deal, as happens so often, you go through and you find that there's some construction project, ceiling has fallen in or leak of plumbing that is partially done, then you'd want to make it a condition that repairs are completed by closing. And for that reason, you would have to inspect. This fact situation gives us quite a list of chattels. I've never seen an agreement which referred to rose bushes or elm trees, although I have wished I had, because some clients become very emotionally attached to their rose bushes, and I have had deals where the whole back garden was stripped by the time of closing. It shouldn't be necessary. They are fixtures. Section 15 of the Conveyancing and Law of Property Act would include them. While discussing with your client the chattels, I think that this is the time to discuss with him what the value is. I mean, in this case, he's paying for firewood, stove, refrigerator, freezer, washer, dryer. You're going to need the information eventually to prepare the retail sales tax, the land transfer tax and retail sales tax affidavit. Incidentally, you may have noticed that, or heard that in the last Ontario budget, a lot of these appliances were exempted from retail sales tax, but they're not exempted on a resale. They're only exempted if you or I go to a licensed vendor, Eaton, Simpson's, to buy a new stove, refrigerator, not incidentally a dishwasher. They were not exempted, so that that is of no assistance to us in preparing our affidavits. The reference to cable TV, I don't think it needs a condition, but I would suggest that it be added to paragraph 16, which is the paragraph dealing with adjustments. It lists a lot of things that you're going to adjust. If there is cable TV, then I think you'd want to adjust for the amount that has been prepaid. Miriam, I think that's all I have.
Thank you. Thank you very much, Don. I think the reason I didn't mention his book is because I've always been jealous that I didn't write it. I love that book, and I understand that if we're lucky, we may see the third revision coming out soon. For those of you who came in late, please don't think that you've lost your mind. The lectures for today are not, at the request of the lecturers, handed out. They'll be handed out next week. So you will have all your material if not there. Now we're going to have our 1-minute break, and then we'll be back to hear what the other side sounds like.